Good evening, everybody, and welcome to Wednesday Night Live from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you all for being here on a Wednesday night and spending some time with us. I see a lot of new names in the chat, and I think that there is a reason for that, but also a lot of familiar names, Pammy and Kathy and all of the folks that, Kathy Davidson, so good to see you. We've got some fun for you tonight, and I'm very glad that you're here. And I'm very glad that we've got a big group because we have a really interesting case to talk about and a really interesting person to walk us through that case. First of all, because we have a lot of new names, CJ, hello, Alicia K. Mayo, hello. I want to introduce myself really quickly. My name is Joshua Ritter. I am a former LA County District Attorney. I was a prosecutor for 10 years. I have now been in private practice as a defense attorney for nearly as long. What we do here, and the whole reason we started Courtroom Confidential, is we're trying to give you both sides of the courtroom and bring you as an objective, a perspective as we possibly can. So we hope that we accomplish that. Here's what we're doing tonight. We're going to talk about the Linda Stermer case, a fascinating case in and of itself, just for what took place, what the police or prosecutors are alleging, what her defense is. But it's made even more fascinating by the entire history and how it got, she was convicted before and how it now got booted back to the trial court. And we're going to get into all of that too. And to help us walk through all of that is going to be Scott from Recovery Addict. I know a lot of you are here because of Scott. I'm a big fan of Scott. He is the best place to watch trials live. He's doing something that nobody else is doing on YouTube, and I really appreciate him taking some time to talk to us about the Linda Stermer case. While we're talking about that, we're going to have a poll for other cases we can talk about with the time that we have left. And those cases are the Ingolf Tuerk case, really fascinating case about a doctor who is alleged to have killed his wife, strangled her, and then drowned her in a pond. Karen Reed. If you've been living under that true crime rock, you already know about Karen Reed. And the Christopher, I pronounce it Schultes. I'm now being told that it is Scholtes. And I have bones to pick with people who are saying Scholtes, but I'm being told I'm wrong. I would like to hear from you. Is it Schultes or Scholtes, as I'm being told? In any case, we can talk about that case. It's a very tragic case about a man who left his daughter, his toddler, inside of a vehicle for several hours, and she ended up dying. Tragedy of a case, but he just turned down a plea deal for second-degree murder, and he's now going to trial for first-degree murder. So we could talk about that too. So Ingolf Tuerk, Karen Reed, and Christopher Schultes or Scholtes, depending on if you're a tomato or tomato person, we can talk about one of those. In the meantime, please hit the like button, subscribe if you haven't. Let's give, all of the sacrifices we need to the algorithm gods. Thank you to everybody who's currently in the live. I want to say thank you to our Facebook viewers who are also watching this as well, and to the replay crew if you guys are watching this later, and to all of the recovery addicts who are in the chat. Thank you guys so much for being here. I'm going to shut up now because you're all here to see my friend, Scott. How you doing?
Well, Josh, I can tell you, I am not the right person to ask about pronunciation. So on that name, you're on your own. I'm doing well. How are you?
I'm doing very, very good. You watched this case all day today, but you still got some, I hope you got some food in you and you got some caffeine in you, and you still have some energy for us to talk a little bit more about it.
This stuff energizes me. I never get tired of it. So that's great. I'm happy to be here and talk about the Linda Stermer case today.
Yeah, it's a fascinating case too, because of, like I said, it's rare to have a case where it's involving, they're saying that she beat him, then she lit him on fire, and then when that didn't kill him, then she ran him over with her van. She was convicted. So I'm just going to catch everybody up. I'll do a quick recap so everybody knows what we're talking about. The allegations are in that, what year was it? 2007, January 7th of 2007. Her husband's name was Todd Stermer. This is in Lawrence, Michigan. The prosecutors believe that she beat him somehow with some sort of blunt object, then lit the house on fire, And then when he goes running from the house, literally engulfed in flames, she runs him over with the family van because that wasn't enough. He eventually, I think, succumbs to injuries from the flames, right? It wasn't the beating or the van that they believe actually killed him. The poor man burned to death. Prosecutors say that he found out that she was having an affair. That's what caused her to kind of lose it. And that she doused him in gasoline in order to light everything on fire, which becomes kind of a point of contention here. What was actually the accelerant used in this case? The defense says no. They had oil lamps because I guess they lived in the 1800s in their house, and she had candles burning, and it was this horrific fire that started. And when she hops in the van to go get help, she accidentally runs him over on the way to go get help. She was convicted in 2010 and sentenced to life. And then in 2018, they overturned that conviction because they're saying, amongst other things, prosecutorial misconduct, everything else, they said that she had ineffective assistance of counsel. And this is the first thing I want to pick your brain about. Ineffective assistance of counsel because the defense failed to call an arson expert. And that was kind of mind-blowing to me because whether or not you call an expert, a lot goes into that. That, first of all, money. Can you afford the expert? You can, yeah, that might be a great decision, but if nobody can afford that expert, you're not getting the expert. Two, it's kind of a strategy thing, you know, whether or not you call an expert or whether or not you cross-examine their expert. But in any case, the appellate court felt differently than I do and felt that that was a big enough mistake to call it ineffective assistance to counsel. And now here we are in 2025, and she's got a brand new trial for herself, and you've been watching it. So there is my long, supposed to be brief intro to this whole thing. Where do we stand now?
Well, you've covered it all. That's it. So we're just going to wrap up. No, just this case is so much fun to look into. First of all, it's tragic. It's terrible. But if you back up all the way to the appellate court decision, deciding that she actually got a new trial, it was a 2-3 decision, or sorry, a 2-1 decision. So one of the judges dissented, and that dissenting judge wrote quite a bit. He had a lot to say about this, and he's like, "This is ridiculous. The only thing we don't have in this case is a video of her committing the murder. Everything else is there. What are you other two, my fellow judges? What are you seeing here that I don't?" And he says, one of three things happens. Either Todd did it to himself. You've got the Todd died accidentally, which, there's that, or Linda murdered him. Those are the three that it could be. And he breaks down, he says, here, this is why this can't be true. This is why this can't be true. And here's the last one. We've got Linda and all her stories and everything that doesn't add up, and all the coincidences that fit together, from the gas can she was buying the night before, to her affair that was just found out the day before, to her sending the kids off to the mall that morning. Then boom, there's a fire suddenly after that. There's so much in this case that you can see why the first time around the jury voted to give her life without parole. I mean, she served nearly 9 years of that as well before this appeal came through.
You know what's interesting hearing you talk too is that when the appellate court makes a decision, it's not even so much like they can second guess things, right? They can say, hey, they probably should have called an arson expert. But the next question they should be asking is, did that have enough of a profound effect on the outcome that we feel like she didn't get a fair trial? In other words, could the fact that they did call an expert have changed the outcome of the case? But as you're pointing out, back then at least, it sounds like even if they had called an arson expert, there's so much overwhelming evidence to tie her to this thing that it probably wouldn't have changed anything anyways.
Yeah, there was a ton. And I think the biggest problem, I mean, it is the expert testing and the expert testimony that has really got her in trouble, because there were other flammables in the house. There was heating oil they were using. There was kerosene in the lamps. But gasoline is not burned in either one of those. And that's what the test came back to, was gasoline on his pants, gasoline in the gas can. There should be no gasoline in the house. And how do you account for that?
Yeah, that's not something you accidentally get on you. That is not something that you're dealing with in a home environment that might accidentally splash onto you unless somebody's using it, in a very nefarious way because they're trying to kill you. I missed something. One of the most important things I wanted to ask you is, you had what number did we get up to on the made up word count? More importantly,
I think we're at 24 made up words.
explain that to everybody if they weren't watching.
When you're listening to somebody talk, and I do it all the time. I'm guilty of this. First of all, I make up words, I mispronounce words all the time. So I'm sort of laughing at myself as well. But we're up in Michigan, and they say things a little differently, and sometimes they just say the wrong words. And so I've been keeping track of a list of words they've said long, like Scintilica. Scintilica. I'm not sure if that's like a little piece of Metallica mixed together. I don't know what it is.
Yeah, a scintilla of Metallica. Yeah, Scintilica.
And some are just mispronunciations like antihistamine. Things like that. We've got, I could read you the list pacifically instead of specifically. That's one that we hear a lot. Flammable, simplicit, excavate, corroborate with a W.
I love it. I love this.
Ambulance with no M.
Bar instead of fire, says gossip, rumor, and innuendo.
Yeah,
good.
There's just a lot. So we're laughing a little bit. It's been a little bit of everybody. I think the judge has a word on there. We've had some witnesses that have had some words. A couple of the attorneys have contributed, one more than others. But it's something we just like.
I am guilty of that as well. I feel like, especially if I'm doing like a live news thing where somebody's asking me a question, and I know the word I want to say in my head, and for some reason it doesn't get to my mouth. And so I just say it quickly and hope that nobody notices and hope that nobody's recording. And this is just something that somebody feels like they may have missed it, moving on. Right.
Yeah.
All right. But tell us seriously, how, this case is old to begin with, made even older by the fact that by the time they granted her a retrial, it took them several years since then to actually bring it to trial. These cases usually don't age well, and when they age poorly, that usually doesn't help the prosecution. Are you seeing that effect take place in this case?
Yes, and in a couple big ways. We've already run into a situation where evidence that was introduced in the first trial isn't available in this trial because the company just went out of business, and the records that the expert relied upon are gone. Things like the testing of the red towels that were down in the laundry, where she says she was doing laundry when the fire started, that tested positive for gasoline. That can't come in. The company's gone. There's no record. The expert got there on the stand, and the judge said, Michigan law, that underlying evidence has to be available, and it's not. So It's not coming in.
Wow. And too, who can really blame them if she was convicted and sentenced to life? It's not like there's preservation letters still in effect and investigators were, obviously you're always like kind of thinking about, well, let's make sure all appeals are not exhausted, but at the same time, you can't expect companies outside of law enforcement to hang on to this stuff for forever.
Yeah. And that is not all just the evidence. The evidence is old, but at the same time, you've got almost everybody, the experts that are taking the stand have retired. Some of them have not testified in years, and now they're brought back and they don't recollect anything. They're like, well, yeah, I remember the case. I looked at the report and it's starting to come back to me, but so much of that memory is just gone, or they're remembering incorrectly. Because once the case is over, they might have watched all of it and listened to all the evidence and talked to other people, and their memory becomes sort of what the other person's memory was. And so we have all these people who have to have their memory constantly refreshed with the old, their old document, their old report. And it's painstakingly slow sometimes. But it's brutal to watch. It's just like this case was dying of old age before it could reach a conviction.
I'll tell you a quick story. When I was a prosecutor, I had a case that was a cold case. It was from the 80s. It was a murder case. And the reason it had gone cold is that the suspect had fled and he was a fugitive for decades. And then they finally found him, and now we're putting on the trial. But I'm dealing with like Polaroids, literally are the pictures of the crime scene, and then trying to contact these officers. The patrol officers had, spent an entire career as a cop and now retired. And then, my medical examiner has long since retired, and all of this kind of stuff. And I remember, and I'm going to use a curse word, and I apologize, I try to avoid that, but I call up the medical examiner, who is a wonderful, kind woman. But I say, she answers the phone when I call, and I say, "Hi, this is Joshua Ritter from the LA District Attorney's Office." And she goes, "Oh shit." Because it was like she knew what that meant, that somehow some old case had come back to haunt her. But it was funny because, like you said, no one could testify to their memory. I had to put these people up, and we had to go through the charade of saying, I want to call your attention to the evening of 1987, May 3rd, like they would remember. And all of them had to sit there with their reports and can I refer to my report to refresh my memory? And we were just basically reading to them, to the jurors, the old reports, because that's the only way anybody could testify to anything that took place. That's not the best way to put on a trial, especially of a trial of this significance.
And you, in order to get to the point where you can read that to them, first they basically have to forget. They have to say, "I don't remember," or testify, even worse, testify differently than how they testified before. Right. Are you sure that it was on the right, not on the left? Yeah. Do you want to check your report? So there's been a ton of that. The jurors have been able to ask questions in this trial as well, and it's fun to see them.
Let's get into that, because that always gives me sweaty palms when you hear that there's a jurisdiction where the jurors are allowed to ask questions, and I'm starting to warm up to the concept of it. But how do you think that's playing out here?
Just from what we've been able to observe, and we've had somebody in the courtroom one day, but there's one juror who is like an engineer or something, who understands advanced principles, scientifically, and is asking questions about it. And I don't know if he'll make the deliberation or not, but there's just a couple jurors that are asking most of the questions, and they're intriguing. They're paying attention. They're paying attention to details. They're challenging. Like today, there was a question where the defense was asking a witness if somebody else had called 911, and the juror asked the question, "Was it you or the other person who called 911? Because my notes," and they're checking people on that. It's been really good. So I do like it. I'm a big fan because we get to see into the jurors' minds. I know it would be scary as a prosecutor or defense attorney to have that, but because you never know where they're going to go, right?
Well, yeah, and I was trying to think of why it bothers me. So I think, one, I'm just not used to it, but two, you take such great pains to make sure that the evidence, you argue a lot about what evidence is going to come in and what questions can or cannot be asked. And so I guess you're worried, are they going to go off on some track that they're, leading down a pathway that we're not allowed to take them to begin with? But the judge gets to decide which questions to ask and answer. But the more I think about it, it's like, isn't it always true that once a trial is done and it goes to the jurors deliberating, that the first questions that come out are things that nobody ever thought of? It's like all of these mysteries they've been wondering about for weeks while you've been putting on the trial, and that's what they're most confused about. Well, this kind of takes care of that along the way. You're understanding where are they struggling? Where are they hung up? What is it that they're really confused about? And maybe you can course correct along the way.
Yeah, and a savvy defense attorney might look at some of the questions that aren't allowed and read into that where the jury's at and questions they have. We might not hear them and they're not read in court, but knowing what the jury's thinking and what's on their mind might influence. Maybe you need to solidify some, buttress an area where you have weak testimony, or maybe they missed something before that needs to be brought up again. So
that's very clever. So they can review all of the questions with the judge. Yeah. And they can get an idea of who's thinking what, and maybe tailor the rest of their case to address. Do they know which jurors are asking which questions? I imagine the juror has to put what number they are or something on the question.
I believe the questions are kept in the record. And so I think there's juror numbers on them. But if only two jurors are handing in paper and one's still writing, then they hand it in, it's pretty obvious who turned it over. It's not like, no one has to wear a blindfold. I think they understand where people are, but at this point it's luck of the draw if they make the deliberation team or if they're in the alternate category.
Crazy. First of all, I wanted to thank Kathy. We just saw it up there for gifting memberships. That's very, very kind of you. Appreciate that. There's another interesting thing taking place in this case where her significant other is involved as part of the defense team, or what's going on with that whole drama?
We don't know a ton about him. All we know is that I believe it was the end of last week. There was an issue that was brought up, and we caught the tail end because the audio sort of cut on as this was being discussed. But the judge was saying, "Hey, what's going on? Who's been talking to a witness? Why has somebody said that the defense team's been calling?" And we figured out that, or the judge figured out that the defendant's significant other, like the person she's currently dating, is assisting the defense team and was doing something to contact them and remind them of dates or something as far as court appearance or something. It didn't sound like it was bad, but it was. You can't be doing
Yeah.
that.
Yeah.
And the judge dragged out him that he was in fact, her significant other, and started playing this dual role. And she says, there won't be any more of that. You are done. No more contacting any witnesses for either side going forward.
Interesting.
That's him. That's him there in the gray.
On the left. Yeah. Him in the gray there on the left. Talk to us a little bit about the defense team, because from the testimony I've seen, they're fairly aggressive on this whole thing. Like they're not really playing this with a soft touch. What do you think?
I would agree in most cases. There was a little bit of softness today, but they're challenging. They're challenging people, and it helps because memories are poor. But they're sort of standing up to bat and swinging and giving it their go. They're swinging for the fences every time, because if they can get a little piece of evidence out, like they did with this, the witness with the red towels with gasoline on them, they got that excluded. That was huge. It's a huge win. They're going for all those things. And this case is going to be a little different than the first case for that reason. They've been able to sort of rattle some people and get them angry on the stand, which is a tactic. Usually we as viewers think, oh man, this defense attorney's a jerk. Why is he being so mean? It's a tactic to rattle somebody, get them off their prepared lines, their prepared, testimony. Here's what I'm going to say, and maybe get them to say something they didn't intend to. And we've had a little bit of that slip out here and there as somebody, says a little bit more that might open a door to something that's problematic. And they're exploring every bit of that they can. So I like it. I like a good drama case like this. So
yeah. I like it too. I mean, I applaud, listen, that's their job, right? I mean, somebody's life is on the line. If I were on trial for murder, I would expect my attorney to be, fire and brimstone as well, as long as they're kind of reading the room and understanding that it's, the jurors are not getting turned off by it. Tell me if I heard this right, and I hope this is the right case, but there's the potential that her children may be testifying. Have you heard about this? For the prosecution?
Yes. Linda has 3 sons and 2 daughters. The 2 daughters did not live with her. They were from a previous marriage. But at least 2 of the sons are not on her side when it comes to the facts. They would be testifying for the state against their mom. I believe at least one of the daughters is on her side, and I think has even been in court a couple of days. So, it has split the family. I'm waiting to see. That's probably going to be one of the closing witnesses we get, because there's some questions we have. She's told so many stories about what happened that I think the sons will be able to clear up some of those points, and we'll get a second perspective and see if Linda was lying.
We don't have an idea that they're somehow going to say she confessed to them or something like that, right?
I don't think it's anything like that. It might go more, say, like, for instance, the day of the murder. Assuming it was murder, I'm already giving my hand. You can see which side I'm on.
Right,
the alleged murder. The sons were sent away to another town to gave them some money, went to go see the movies, hang out at the mall type thing, and that morning they were told, Dad's not feeling well. Don't go in. Don't go look at him. Everyone just go. You guys go. And that was right before the fire started. I'd like to hear from the son's perspective what happened that morning, because there is allegations from the first trial that hasn't come in yet that she had told another friend that she was trying to sneak into the house to remove a mug that had some sedative in it, that before the police found it. And if he was drugged and then beaten before he was burned and then run over, it's just one more element to the crime that the jury would get to consider. But hearing what the sons have to say about that morning, about the gas cans, about why you'd be driving the van around the back of the house. Was that a normal thing? I think that would be very, very interesting for the jury.
Too, they don't have to, we say testifying for the prosecution. I mean, the prosecution can call anyone a family member or otherwise, and it doesn't necessarily mean that they are team prosecution or team defense just because they got called by the prosecution. But if it seems to the jurors from the way that they're answering questions that they believe she was involved, they'll pick up on that, and that could be hugely impactful. A family member, her own children feel that she's responsible for this. If they pick up on that, just even through normal questioning, I could see that being something the jurors will really find to be important to them. I mean, significant to them.
Yeah, we haven't had a lot of that yet from neighbors that have testified yet. People that were on the scene who showed up, who called 911. A lot of them have sort of said, "This is what I observed. It is what it is." Linda told me this story, and the problem is Linda talked to almost all of them, but all her stories are different. Some in major ways. Some where she says that she got in the van and was driving away and heard an explosion, and Todd came running out on fire. Others, she says she heard Todd yell to her, say the house is on fire. She went up, she saw him engulfed in flames. She ran outside, got in the van to drive away, was driving away, saw him come out, tried to pull up to get him to stop, somehow ran him over, then parked the van in the back instead of getting help. There's all these stories that just conflict, and each neighbor is giving the version they heard. And none of them are adding up, and a lot of them just leave questions in our mind.
I get the impression, but I want to hear from you, that you feel the prosecution is probably building a solid case in this, even as old as it is, even with all the delays, that it does seem like there's some reasonable suspicion rising to the level beyond a reasonable doubt as far as how they're putting together the case.
Yeah, I think they need to do more to cover that one possibility that was raised by the appellate judge, saying, is this something he did himself? Because one of her stories does bring that up. In one of her versions, she told someone that Todd basically said, because she was allegedly having an affair, if I can't have you, then no one will. And it was supposed to be both of them dying in the fire in that scenario in the story. That's a possibility the jury has to look at and say, was this something Todd might have done himself? I think they need to, and we'll have a few more witnesses coming up. They've got a couple more days left on prosecution to cover that. But
it's a real savage way of killing yourself, though, to light yourself on fire. That's a hell of a way to try to kill yourself.
Yeah. And
then how does that explain the blunt force trauma? And then how does that explain her running him over with her van? I mean, I don't know. It sounds like that might be a question that needs to be addressed and answered by the prosecution, but it would be a hard defense to swallow, in my view. Let's answer some of these questions if you don't mind. Hold on, I found. Oh, here was the one. Courtroom Confidential. Ask Scott about the yellow notepad. It's a good story. I hope I'm not setting you up for something I don't know about here.
No. This is good. On the defense team, you saw the picture with her and her significant other. The other defense attorney has a habit of bringing a big yellow Post-it. It's like a legal pad, but it's poster size. And he brings it, he sets it up in court. And as people are talking, he gets out a Sharpie and he's like summarizing or emphasizing points. And he's got it set up right in front of the jury. And he's like, did you smell gasoline? So-and-so did not smell gasoline. And he's got and finally the prosecution says,
like it's viewed in a way so they can see it?
Like an exhibit. Yeah.
Oh.
It's on the easel right there in the court.
Oh, interesting.
And the prosecution's like, Your Honor, this is too much. This has to stop. Yeah. And the judge agreed. And he's like, this is how you teach somebody. They hear verbally and they see it. And she's like, you can use it in closing, but put it away. And he tried to bring it out again, and they had the same battle again, and he had to put the notepad away. So we sort of joke about it, but we are going to see it. I'm positive on closing. He's going to bring it out and he'll use it to full effect.
That's a gutsy move to actually try to create a live exhibit as it's going on. But I feel like if he could do it almost to the same effect, if he just had it on his table and, with with one of those really squeaky markers, continued to write on it, and then just brought it up in closing arguments.
We were joking that he should use that pad as his legal pad during court. Just be scrolling that, and then at the end he can hold it up and show it to somebody. But I think he is going to do it. I think it helps the defense because they're, even with all the witnesses, people saw different things. A lot of people said, I didn't smell gas when I got there. I was the first guy on the scene. I knelt right by the body. I didn't smell gas. And other people said I knelt by it, and immediately it was like, oh, there's gasoline or some flammable, accelerant here. So the defense has asked a lot of the same questions. You didn't smell gasoline. You didn't know where the fire started. You didn't know who started it. And I think they've got a lot of witnesses that don't know. And of course they want to emphasize that to introduce as much doubt as possible into the case.
Yeah. Joe Sue says, Josh, did you win that cold case? Yes, I did win that cold case. Thank you very much. Thank you very much. It was a fascinating experience though, because it gave me a lot of perspective and understanding for how difficult it is to put together these cases. Like you said, memory's gone, evidence gone. The evidence that you do have is like not recorded the same way. We're not dealing with digital photographs. Like I said, we're dealing with like Polaroids, and half of it you can barely see. And it was a difficult case to put. I appreciate the experience, and I give most of the credit to the investigators who were able to help me piece that thing together. But it was a hell of an experience. This is another one. I hope you know where we're going with this. Do you have the video of the lawyer and the pretend frying pan? This is Martha Ivy asking.
Same lawyer as the notepad was asking an investigator, and his question was, usually when you get hit with a frying pan, it's like, and he demonstrated with his notepad, like his binder, and hit himself in the head. And we put it on Twitter with him repeating the hit a couple times, and he stumbles out of frame. But it was a weird question. I did
see that he smacked himself in the head with the notepad.
It was a loud thunk, and he did the whole, and it was good. It was funny. The question was actually objected to and sustained. So I was like, that's not proper demonstration. Plus, usually when you're hit with a frying, who knows how it usually is when you get hit with a frying pan? I mean, that's just an absurd question to begin with.
Gossip, rumor, and innuendo, thank you so much for being here, says, how could anyone convict that hair? And I'm glad that you asked this question, because I made a point too, Kaylin, if you can show it. This to me is there was a lot of thought going into her presentation in court. And I think that they are doing their darndest to be like this sweet older woman. How could she possibly be guilty of the awful things she's being accused of? How do you think that is playing? What is her demeanor in court? Is she presenting that kind of persona?
Yeah, she's been crying in court. The tissues come out a couple times. You'll see her wipe the eye, but not where the tear is. Just especially on the jury side, make sure they see the actual tears. I think they benefit from the fact that she is out. She's out on bond. Yeah. And so they do have the ability to, worry about presentation more than you would be able to if you were in custody and, quickly changing in whatever jailhouse clothes are available to be in street clothes. But she does present well in court. But, there's a lot
this is something interesting too. Colorado asked the same question. Has she been out of jail this whole time? So after the appellate court, and correct me if I'm wrong, ordered the retrial for her, bond was then set again. So she was life sentence. Mm-hmm. But now when you're looking at trial again, you're given the opportunity to have bond. So bond was set. She was able to bail out. And that might have added to the amount of time that this took to get to trial again. From 2018, when that order came down, the overturning that, till 2025, makes no sense to me why we're talking a matter of 7 years to get this thing to trial. Unless you're out of custody and you can go into court every single time and say, Your Honor, we haven't received all of this. We need another 6 months to prepare. We need this, we need that. And realizing that the only thing in your favor at that point is just trying to make this case as old as possible.
Yeah. I think part possibly one of the issues that came up, and I've got to thank Josh Hutchins, one of my moderators, for finding this. There was what the judge refers to as a jailhouse snitch. Her words, not mine. A jailhouse snitch in this case, where supposedly Linda told about an injury, about hitting him in the back of the head, and this jailhouse snitch had information that was not known to the public, that could be corroborated with on-scene evidence. That witness has passed away, and I don't know when she passed away, but there was a legal fight that went all the way up to the Michigan Supreme Court to see if they would be allowed to bring in that testimony in the documented form that it's in, instead of normally calling a witness, as you need to have them on the stand to be cross-examined. And I believe the ruling was that will come in, so we will hear that jailhouse snitch account.
Oh, wow.
Posthumously.
And that type of stuff is incredibly powerful. When jurors feel like they are hearing someone confess to something when they feel no one else is listening, that to me is the type of stuff that seals a case for jurors. Jurors love to hear, in my experience, they love to hear anything that comes out of the mouth of the defendant. It's that if that's the defendant testifying, if that's the defendant during an interview with police, but especially if it's something surreptitiously recorded or like this jailhouse snitch situation, they just feel like, wow, we're getting an inside perspective to this person. And if that is anything close to a confession, that might be enough alone. I mean, those are the real impactful pieces of evidence. Madeline asks, how did Linda present in the first trial? Were you following that, or have you seen any of the first trial? Do you have any insight on that?
That was way back in 2009. I did not follow it. I've read sort of like the appellate records and some of the filings on, and it's interesting to read about all the evidence that came in. It's no surprise to me, based on what came in during that trial, that it was a unanimous life without parole decision, based on what they saw. And obviously they had a little bit more than we get here. But the part that I love about the old trial and the new trial, I've lost my train of thought here, is you have original testimony that's not people that have forgotten. So these are people who are active in their career at the time they're testifying. They're mid-career, not this was 7 years ago, I retired, and that's what I was doing. So the testimony is a little bit different there. It's fascinating. It's fascinating to watch, especially from the appellate judge's position, to see how much evidence there was, and then see that the two judges ruled in favor of granting an appeal on just those ineffective assistance of counsel and prosecutorial misconduct, which was an issue. I mean, the prosecutors in closing called her a lying liar who lies, and then sort of bolstered their own witnesses, misstated some of the testimony from another witness. There were issues, and that ineffective assistance of counsel was more than just not calling a fire investigator. Her counsel didn't object when prosecution did that, and that obviously had an effect on the jury, or a possible effect. So I love it. I love looking at the background. I think this case, I mean, if I could put money on it, I don't, but I'd say it's going to probably end the same way the first one did.
Yeah, it sounds like it from everything you've explained. Last question I have is, do we get any inkling of whether or not she's going to take the stand?
I don't think she would.
Yeah.
I don't think she would.
Yeah. Why mess with it, right? Well, I mean, like you said, though, if everything seems to be going the way it did last time, maybe she feels like this is her last chance at a Hail Mary type situation to see if she can't pull out an acquittal.
Well, talking about going the same as last time, this courtroom has been a mess. And I don't want to speak bad about the judge, but she's not controlling it very well. The lawyers are running roughshod over her. There are objections, and the lawyers just sort of sort it out amongst themselves. Never mind. I'll do this. I'm going to ask this question. I'm just doing, and the judge just sits there.
Lets it happen. Wow.
Yeah, and I mean, rulings go unruled. The objections go unruled on, because the other guy just pushes through.
Yeah.
And so I'm not very happy about that, but.
And attorneys will do that. If you give them an inch, they'll take a mile. And if they feel like the judge is not stopping them, they can get very chippy. Scott, you are such a gentleman, and I thank you so much for taking the time and sharing your insights on all of this. What do you got going on for the week? So you're going to be covering this trial. Do you have plans on other cases coming up soon? Tell us what you got going on. And it's Recovery Addict, everybody. If you, I'm sure everybody who's here already knows, but if you don't know, please go check out Recovery Addict.
Well, this is going to be a surprise to everybody. We thought about covering Lori Vallow. Believe it or not, that one I think is going to be more problematic for how we like to watch court than following Karen Reed. And I think we're going to follow the Karen Reed retrial.
Oh boy,
just look at it as a new juror. I mean, as hard as that's going to be, having just watched the one trial and knowing all the information about the judge and the witnesses and everything, look at it for just what comes in this time. I'm hoping that in that Karen Reed trial, the state has a better theory because their first one sucked. And the defense just completely comes in and roasts the state for the terrible investigation. I'm hoping for a great trial there. And I don't have a dog in the fight. I'm not team Karen or team prosecution. But I think that's where we're going to go, and that might surprise a few people.
Yeah, it surprises me. I think you are in for a good trial because, first of all, you've got some powerhouse attorneys on the defense side of things. And then with the addition of Hank Brennan to the prosecution, I know he's got some fans and I know he's got some haters out there, but I will say that as far as the quality of a trial advocate, it has gone up a notch. No shade thrown to Adam Lally, the original prosecutor, but Hank Brennan has, I think, demonstrated that he's going to be a formidable adversary for the Karen Reed team. So I do agree that it's just from a purely entertainment perspective, it's going to be a very interesting trial to watch.
Yeah. And I mean, even the judge is in on this one now. I guess there's a lawsuit against her for some of her rulings about out-of-court demonstrations, and the drama has started. We're going to try to keep it focused just on what happens inside the courtroom.
Good luck.
Wish me luck.
All right, my friend. Thank you again. Really appreciate it. Always appreciate you taking the time and all of your support and love that you give to this channel. Thank you.
Thank you.
All right, take care. Oh, I love Scott. He's so wonderful. And if you guys, I'm sure that you all know already, but if you guys have not heard about or do not follow Recovery Addict, if you want to go anywhere and watch a trial live, there's a lot of good YouTubers out there, but he is one of the best because I think he just, manages to add this extra kind of element with the different camera angles and being able to switch around to different courtrooms and taking calls while it's going on. It's really, really fun, and you should definitely check it out if you haven't already. Thank you, Jamie Jane, for becoming a new member. Thank you, Doracle, for becoming a new member. Misty Peterson. Wow, I'm loving this. Thank you all. Josh. Oh, do Schultes, close to my home. Okay. Schultes or Scholtes? Did we ever get a result on that, by the way? No one? Kaylin's telling me no. Kaylin, by the way, is Team Scholtes. I'm Team Schultes. Still unclear. We should probably have the name of the defendant correct before we talk about any of these cases. Do we have results, though, on our poll, Kaylin? I'm hearing yes. I'm getting nods of yes. 40% Reed. Of course it would be Karen Reed. All right. We'll talk a little bit about the Karen Reed because there was a couple of interesting decisions that were made. And then I'll tell you what, if we have time, and I think we will, we'll get to some of those other cases as well. Maybe Schultes or Scholtes, if we can ever get a final decision on how it's pronounced. But let's get into Karen Reed. What happened recently with her case? Okay. So 2 decisions came out within the last few days as we're leading up to trial. By the way, they've been doing jury selection and it's going along a lot faster than I expected. I thought that this case would take they estimated that. That wasn't just me picking this out of nowhere, but they talked about this taking a couple of weeks to pick so many. They had to pull so many prospective jurors. They felt that the media attention, the recent documentary, all of this was going to make it nearly impossible for them to find anybody who had not already made up their mind about this case. What they are finding, though, I think, is an inordinate amount of people who have heard about the case, an inordinate amount of those people who have made up their minds about the case, but they're still finding enough people who either say they've heard about it but haven't made up their minds and carry no bias, and that's believed by both sides, or people who just haven't heard about it. And I say this all the time. You'd be surprised. As much as we follow these cases and as much as we're in the weeds, even on these very high-profile cases, there are some people who just, it's not a part of their life. They're worried about their baseball team. They're worried about their kids' school. They're worried about what the Kardashians are up to, just a bunch of other things in their life. And they're not worried about Karen Reed. And they may have heard the name, but they have no idea what it means. But all of that being said, they have now, I think the number is picked 7 jurors. So they're, I don't think they're halfway, but they're getting close to halfway, and we're only into day 2. So they might have a jury by the end of this week. Well, maybe not. 2 more days in this week. Maybe we'll bleed into next week, but I think that they will be having it closer. Thank you so much, Pammy, just cuz, and I appreciate you. Thank you so much, Joy W. Everybody, I appreciate this support. So the 2 decisions that came out. First of all, there was this defense wanted to bring in a expert. His name was Michael Easter. He was a former FBI agent, and he was going to be an expert on police procedure. First of all, this is not a new trick. This is something that defense attorneys have tried many times before in other cases where they are trying to put the police on trial, right? In every trial, if you're a defense attorney, you've got to have a bad guy. You want to know who taught me that? That was Alan Jackson. He said, in every case, if your bad guy is not your client, then you need to provide the jury with a bad guy. So who is the bad guy going to be? Is that going to be another suspect? Is that going to be the victim themselves? Maybe this is a self-defense case. Or is that going to be the police? But you have to provide a villain because this is a story and they need to know who the villain is. And the defense in this case, one of the villains, most certainly, is law enforcement itself. So they wanted to call a police procedure expert to talk about police procedures and talk about whether or not those were followed in this case. Like I said, this is not a new trick. This is defense attorneys have been trying to bring in these types of experts in cases before to mixed success. In this case, the judge said no. And we can talk a little bit about the reasons for that, but I'll give you a couple of quotes from Judge Cannoni as to why she denied this expert. He said, first she says, and this is a quote, "Through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures and can raise the issues of potential bias by police action or inaction as counsel did effectively during the first trial." So she's saying, first of all, you did this already. You're allowed to explore this. You're allowed to, all of these topics as far as how bad the police investigation was are fair game. I'm going to allow you to do that. Madeline points out red Solo cups. Yeah, horrible stuff. Quality investigation, the grocery bags being used, the snow blower or the leaf blower being used, all of that stuff. Fair game. Get into it. And you can, through cross-examination, demonstrate how all of that was good, or how all of that was poor, and how all of that was outside of standard practices and procedures. And they're going to get that, by the way. There's not going to be a cop who testifies on behalf of the Commonwealth and says, no, it's standard police procedure to use red Solo cups. Or, yeah, we always use leaf blowers in these types of cases. That's always a good idea. No one's going to say that. And if they do say that, let Alan have Adam in that situation. So they're all going to admit that this was outside of standard practice and procedure. And they did that to great effect, I think, the first time around. She goes on to say the court cannot find, and this is why I think she really denied it. The court cannot find, nor has defense counsel cited on Massachusetts case where an expert was permitted to opine on the general competency of a police investigation. And I think this is what it comes down to is, first of all, the Massachusetts law is not kind to this concept. It does not look like they were able to find a case where they've been able to do this in the past, and she's not going to make new law on this case. But also it has to do with the idea of, do you get to call an expert to just generally opine on things that may not be outside of the realm of understanding for the jury? There's one thing about being qualified as an expert, and there's another thing about whether or not the jury needs to hear that information. Peter Tragos from Lawyer You Know made a very, I believe it was him. I hope I'm not giving him credit for somebody else, but I think it was him. He made a great point about you can call a meteorologist to talk about how 35 degrees outside is cold. And you can have a meteorologist explain to you all of that, and they're qualified and they can talk on that subject. But everybody kind of gets the idea that 35 degrees out is cold. By the way, 35 for somebody in California is damn near freezing. 35 elsewhere might be tolerable and not all that bad. But I think we can all agree that that's cold, and you don't need an expert to testify to that. So she's not saying that this investigator, Special Agent Easter, is not qualified to talk about these things. He certainly is, but is his testimony going to actually be helpful to jurors? Or will his testimony, and this is what she didn't write, but I think what is the context or the subcontext to all of this, would his testimony substitute the juror's job? The jurors are supposed to decide at the end of the day, was this police investigation so flawed? They're going to hear about the Solo cups. They're going to hear about the garbage bags. There are the grocery bags. They're going to hear about everything else that was done that can be scrutinized in this case. And it's their job to decide, was that done so poorly that this investigation is flawed from the word go? But if you have an expert up there with all of his expertise and his experience saying this investigation is so flawed and cannot be trusted, will they substitute his opinion for their own opinion? And I think that's really where the judge came out in this whole thing, is that this is not something so outside of their ability to decide on their own. And I'm not going to allow a judge or an expert to substitute their opinion. I keep my studio at a balmy 28 degrees, says Scott. I don't blame you. I usually have the fan blasting on me so I don't start to, quote unquote, glisten while I'm doing a live stream. So I think that's where she's coming out on this whole thing. And end of the day, this is not devastating to the defense. I think this would have been the coup de grace. I think they would have loved it. I think they would have highlighted it. I think they would have, squeezed every last bit of juice out of the whole thing. But it's not a huge setback for the defense, and they're going to do exactly what they did the first time around. And I don't think anybody disagreed with the quality of the investigation from the first time around. The other thing that she did is she gave a ruling on the third-party culprit evidence here. And she basically just did what she did the first time around. This is Judge Canoni again. She basically gave them exactly what she gave them the first time around. What she's not going to give them most significantly, they asked to bring up Brian Albert, Brian Higgins, and Colin Albert, the young man, as possible suspects, third-party culprits. She said no to Colin Albert, and she basically said that is based upon everything that happened in the first trial. I don't think you got to that level. But as to Brian and Albert and Brian Higgins, this is a quote from her, the defendant's proffer is barely sufficient. So she still feels this is a close call. And the history of the first trial casts doubt on the seriousness of the claim. However, to protect the defendant's right to a fair trial, and in recognition of the fact that the defendant has no burden to prove anything under our law, the court will take the same incremental approach as it did the first trial. Defense counsel are ordered not to mention potential third-party culprits in opening statements, but counsel will be allowed to develop the evidence at trial if possible, and counsel may seek an appropriate instruction if warranted after the evidence is concluded. So Same thing she did the first time around. You can develop it. They did develop it. I'm sure they will get to the point where they will get that instruction if they ask for it. I'm sure they're going to make the arguments. None of that will be lost on the jury, exactly who the defense feels is responsible for John O'Keefe's death. But she's not going to allow them to just jump into it from opening statements. The last thing that she says is counsel cannot mention potential third-party culprits in opening statements, but will be given the opportunity to develop the theory through relevant, competent evidence at trial. Again, same thing she did the first time around. If it comes up that she had a relationship with Colin, with Higgins, if it comes up that Albert was a cop and all of this type of stuff that they explored the first time around. Veritas Semper Emigrit, Massachusetts. Sorry, I butchered that. Thank you so much. Says, I think it is reversible error. She is referring to fact the under dispute from the first trial. Let me read this again. I think that it is reversible error. She's referring to facts that are under dispute from the first trial. Oh, I see what you're saying. Is it a problem that she is referring to things that were established in the first trial for making her decisions in this case now? I see what you're saying, Veritas. I don't know if I would go that far. I think what she is saying is, listen, I don't have to speculate as to what you're saying the evidence is going to be as far as these third-party culprits, because we saw it from the first trial. And so I get an idea as to what exactly you're going to cross-examine and what evidence you're going to present. And therefore, I'm making this decision with that knowledge in my head. I'm not going to ignore it. I'm going to assume that what's going to play out is likely going to be the same. But end of the day, she gave them what they wanted. So as far as there being a problem, she gave them what they wanted. They wanted a third-party culprit. They're getting third-party culprits. They're just not getting all three that they asked for. But honestly, going after Colin Albert, it's probably not a good look anyways. All right. I hope I haven't lit the world on fire by talking about Karen Reed. I feel like every time I was telling Scott, every time I talk about this case, I feel like I'm handling uranium because I just don't want to say anything that's going to make anybody's head explode. But I think we got through that. We got some more time. Shall we get to Christopher? Or first of all, what won? I guess we should note nothing won. A tie. She says, hold on. Kaylin, get it together. I move quickly here. I'm going to talk about Christopher Schultes anyways, but let's see what won the poll. Tuerk. Okay. Ingolf Tuerk. Really quickly, this is another case that's going on right now. This is what happened. Back in May, that is Mr. Tuerk right there. Back in May of 2020, Mr. Tuerk is accused of killing his wife. And I can even take out the word accused. He's admitted to killing his wife. Her name was Kathleen McLean. This is taking place out of Dover, Massachusetts. This is in, I think, the same courthouse in Massachusetts at the same time that the Karen Reed trial is going on. This trial is going on. He's accused of strangling her to death. Again, accused. I believe he's admitting to it. Then dumping her in a pond and weighting down her body with rocks in her pockets so that she got weighted down. This case, again, is not coming down to did he or didn't he? Does he have an alibi? Was it self-defense? It's none of that. It's he did it. But they are claiming his defense is that this was heat of passion. The prosecution is saying it's first-degree premeditated murder. And the prosecution is saying, first of all, there's a history of abuse. He discovered that she was cheating potentially. That threw him into a rage. There's previous conversations, text messages exchanged that they talked about in opening statements where he referred to her as a vindictive devil. He's got defensive wounds on him, apparently, and then he covered up the murder after the fact. The defense is saying you can look at all of that and see how that plays into our theory of this was in the heat of passion. They were in a fight. They were going through marital troubles. They were trying to resolve those. Those had come to a head when he realized that she had taken part in an affair, allegedly. They were both very drunk, and he, in that moment, strangled her to death. And then when he was arrested, by the way, he was arrested at a hotel, nearly incapacitated. He was so drunk. And my kind of thoughts on all of this is that nearly sounds like textbook heat of passion type stuff to me. It is this idea that in the moment, there's a fight. I didn't plan any of this. I didn't even have a weapon. I didn't draw a gun. I just used my bare hands and I did something impulsively while I was in that, we talk about heat of passion and a cooling off period. There was no cooling off. I was so inflamed that I cannot be held responsible. And I certainly did not premeditate what I did. And I took her life. Now, the prosecution points to the cover up and the hiding of her body and the drowning of her body and weighing it down. To me, the cover up has nothing to do with the crime. I mean, I say that and I realize that even as I said it, that's not entirely true, but the cover up really doesn't have to do with the intent at the time of the crime. He could still commit premeditated murder or voluntary manslaughter, heat of passion, and want to cover it up, realizing his mistake or realizing, now he's got to dispose of a person that he killed in premeditation. To me, that does not really help move the needle as far as what was his intent at the time of the crime. The only thing here that I feel like is a problem for his team, his defense team on this heat of passion argument is the idea of strangling someone and the idea that he had apparently defensive wounds on him. Because, not to get overly graphic about all of this, strangling someone does not take place like it does on television. Strangling someone takes a lot of time, and strangling someone takes a lot of strength, and strangling someone is something that you can change your mind about as it's happening. So we're not talking about, I lost my mind and I pushed her over a cliff. I lost my mind and I hit her over the head with something. We're talking about, with your own bare hands, holding someone's neck as they are slowly losing life in your own hands. That, to me, I think is probably the best argument for the prosecution as to why we step from the area of, right, just a crazy Jen says, yes, so much opportunity to stop, where we stepped from the realm of heat of passion into the realm of premeditated murder. I've talked about this on this channel before, but premeditation does not mean sitting at home with charts and diagrams and obsessively planning something. Premeditation means you thought about it and then you decided to go ahead and do it. This is not instant by any means, says, sorry, I missed the name there, Petrified. Correct. The way we would explain premeditation to people many times when I was a prosecutor is the idea of, imagine yourself pulling up, you're driving, you're late to work, and you're driving on your commute, and as you're pulling up to the intersection, the light turns from green to yellow. And you decide, I'm late, I can't be late again, I got things I got to do, and I'm going to step on the gas and get through that light. Or you decide, you know what, it's not worth it, and I stomp on the brakes and I make sure that I brake before I go through that intersection. That moment, those few seconds that it takes to make that decision is premeditating about that decision. It is thinking and contemplating, what am I going to do next? Why do I either need to get through this intersection, or why can I stop and wait? And am I willing to take the risk of the danger of going through this yellow light because I've got other things that are more important to me at that time? And we make those decisions all the time, and we do them in mere instances. And I guarantee you this, he thought about taking her life for much longer than it took for you to decide whether or not to go through that yellow light when he had his hands wrapped around her throat and he was strangling her to death. Again, I think that if I were the prosecutor in this case, that is, to me, the point that I would be highlighting over anything else. Special case is what's with criminals confessing and then claiming self-defense? The answer to that is when you're on trial for murder, you're just trying to figure out what might actually be a defense. And many times when you've run out of, I don't have an alibi, I don't have any other excuse for what took place, self-defense seems to be the fallback. Do we got any more questions on this? Veritas says again, I know he is guilty. I just don't like being questioned by police without attorney, leaves much for a chance of them to wiggle out of it. Yeah. This is a great question. Getting back to police, part of their job is catching bad guys, but a bigger part of their job is catching bad guys and doing it the right way. Because if they do something that is abusive of a constitutional right, abusive of a person's Miranda rights, and that confession ends up getting tossed out, that's going to be a big problem. All right. Let's go ahead. Do we have more questions on this? I don't want to jump ahead, Kaylin. Let me see. Let me go through these really quick. JC Broadway says, have they presented evidence of the prior DV? I've been trying to follow this trial, but have missed it. I don't know if they presented it yet, but I know that they are definitely going to present it. And again, that's a great point, JC Broadway, that that is another thing I would present as the prosecution in this case is, by the way, this is not an anomaly. This was not a man who lived a peaceful life and snapped. This is a man with a history of violence who then playing with fire went one step way too far. Let me see. I'm just going to take a quick look here. All right. I think we got to most of them. All right. Should we get to Schultes? We can do that one really quickly, and then I'll get you guys out of here. Oh, by the way, stick around because I have an announcement at the end that I think you all are going to like, and I don't want you to miss it. So let me get through Scholtes or Schultes. Pick your flavor, and then we'll get to those announcements really quick. This case is a very, very sad case. This one really pulls at my heartstrings. Christopher Schultes is accused on July of 2024. He's the father of several children, but one of them was a 2-year-old daughter. This took place in Marina, Arizona, and I might be pronouncing that inaccurately as well. But the story goes that he drives home. It's a summer day. It's July in Arizona. You guys can imagine. You don't need a meteorologist to tell you how hot it is. It is 109 degrees out, apparently, when this all took place. His little 2-year-old falls asleep in the car. And as parents will know, sometimes when that kid is asleep, you just leave that sleeping child to sleep. This was not the right choice for Christopher Schultes to make. He leaves the 2-year-old. Oh, God, this breaks my heart. Absolutely breaks my heart. Leaves her in the car. She was sleeping. His police interrogation, his statement to police is that he left the car running and he left the air conditioning on and he ran inside to let her sleep as he had done sometimes before with his children so that he said that he was unpacking some groceries, taking care of some things. Here's where things really go off the rails and where it really is going to crush you. There's also evidence that he started playing video games and that when he left her in the car, it's 3 hours later before the mother returns home, his wife, and says, "Where's our daughter?" And then he loses his brain and runs outside and finds out that she has, in fact, died inside of the car because that vehicle had a safety feature that if you just left it running with nobody in the driver's seat, it would shut off after 30 minutes. And so that vehicle had shut off after 30 minutes. And this poor, beautiful, beautiful little girl died. And he's beside himself. Mother is beside themselves. One statement that is recorded is apparently, I think this might be a text exchange where the mother says to him, "How many times have I told you?" So apparently she knew this was something that he had done before. "I told you," yeah, these are the text messages. "I told you to stop leaving them in the car. How many times have I told you?" Oh my God. She says, "We lost her. She was perfect." He says, "Babe, our family, how could I do this? I killed our baby. This can't be real." This one's, yeah, I can't, I have a tough time getting through this one. The reason, though, that we're talking about this is he has been charged with first degree murder. And that's interesting to me, because that is fairly aggressive, to sit, because now you're talking about premeditation, right? Now you're talking about, and you can assume intent, right? Through gross negligence, through gross, disregard of human safety. And maybe they are saying, listen, with a history of doing this, realizing the dangers inherent to it, apparently there's evidence that he realized that vehicle did have that safety feature. Combining all of that together, you get to this presumed intent, that gets you to a murder case. But again, I don't know if that gets you to first degree. Now, he was offered a second degree murder plea deal, and he rejected that, and now he's going to trial. Second degree murder would have exposed him for anywhere from 10 to 25 years in prison. First degree in Arizona is life. So he is taking a very big gamble here. And it was something I wanted to talk about because, one, I don't know the appropriateness of, I'm really questioning the appropriateness of the Arizona prosecutors going after him as aggressively as they are. Believe me, this breaks my heart more than anything to think about how that beautiful little girl died. But this is obviously not a man who, um, wished this upon his child. This isn't like an ongoing abuse case that we're talking about here. Is he responsible in some sort of way and should be held accountable? Absolutely. Do I think this is a prison case? Yeah. But is it a first degree murder case? And are we really going to be going to trial over something like that? And I realize they offered him second degree murder, but in my view, there is some sort of way for this case to be settled where the government can still feel like an example has been made, justice has been done, and this man who, now you're going to take away the father from the rest of these children, is going to go to trial over something like this. This, again, I think is a good demonstration of how difficult it is to be a prosecutor in these types of decisions that you have to make. Simi Sharp says it was gross negligence. It's the history that got him nailed. I absolutely agree with you. The wife's text exchange there is probably one of the decision makers for them. I think also 3 hours in the car, that's ridiculous. The fact that he was playing video games, all of it is awful, awful, horrific stuff. Crazy Mom RN says there is a history of the father doing this. His 17-year-old daughter came forward to testify against him. He has a history of this. Yeah. I mean, like I said, I'm not saying the guy deserves a pass. I'm not just saying the guy deserves to, doesn't deserve to go to prison. I don't know. These are the kind of things that I struggle with. And I don't know where there's right answers, but we're going to find out because it sounds like it's going to trial. I mean, think about this. The other thing that's going to happen is you're going to have jurors sitting there trying to decide this too. Do they punish this man with sending him away for trial? Do they say this man is guilty of first degree murder and put this man in prison for the rest of his life over something which he, likely will testify to tearfully about how this has ripped him apart? I don't know, guys. I know that you guys have all got very strong feelings about it. I see your comments. In no way am I trying to excuse his behavior. I guess I'm just saying that, we try to remind ourselves of these are real lives and real dramas that are playing out here. Are they doing lesser included? I imagine that they are, That's a great question, Ohio Palm Mom. Many times what they have in these cases is what's called a sua sponte duty to instruct on lesser included. If there is evidence that this could be a second-degree murder or it could be an involuntary manslaughter, they will get those instructions, because if there's evidence of it to support it, the judge usually has a sua sponte duty to instruct on it. Anyhow, on that wonderfully high note, let's get to some announcements for the week. First of all, big announcement. This is a change that we are doing in our programming. We are starting this month. We've decided to just go ahead and pull the trigger on this. We are starting this month going to be making our Sunday Fun Day show a weekly show. So starting this Sunday, we are going every single Sunday, answering your questions live, taking your voice messages, answering them. I have so much fun doing this Sunday show. And we've been just trying to build up to the idea of, are we going to get enough questions to fill out an entire show? And we just decided, you know what, to heck with it. We think that we are, and we think that you guys are going to come through for us. So that being said, we hope that this will encourage you to leave more voice messages. How do you leave a voice message? I hear everybody screaming. Hey, Josh, how do I leave a voice message? Everybody's screaming all at once. Well, I will show you. If you go, what happened here, Kaylin? What did you do to me? Hold on. If you go to, there we go, thecourtroomconfidential.com, click on this button over here to the right, send a voice message, and then you just work up the courage and realize that everybody here loves you and that this is a welcoming community, and you click start recording and you leave us a voice message, and we will answer as many of those as we possibly can this coming Sunday and every Sunday, every week, as long as we can keep this going. So CJ says, I'm so juiced. Where's CJ? I'm so juiced. I'm juiced too, CJ, and I hope that you guys are as well, because we're really excited about it. We were just like, you know what? Let's just do it. We have so much fun doing it, and we think that the questions will come. That's the only thing that's been preventing us before now, is we thought we're not going to get enough questions, but we think that we are. And hopefully now that we're doing it every week, that means that the questions could be more topical, because we can talk about ongoing cases, and you won't have to wait 2 weeks for us to do that. So that's this Sunday. But because of that, though, we're going to not do our Monday live show. We used to have that kind of pregame show before the Monday premieres. We're not going to do the Monday live show, but we are going to have the premiere. And this Monday, time, it is 9 a.m. Pacific, noon Eastern this Sunday. Be there, Martha. And Martha, go leave us a message and ask us a question right now while you're asking. And then you can tune in at 9 a.m. Pacific, noon Eastern this Sunday. This Monday, though, we are having a premiere, the newest in our conversation. Oh, no, pardon me. What you missed last Monday was the interview with Greg Hartley from the Behavior panel. Check that out. Wonderful interview. Really enjoyed it. Had a great time. Kaylin's trying to show the graphic, and I think I messed her up. There it is. Sat down with Greg. He gave us some insights on how to read people's body language, by the way. So I can tell now when Tiffany's lying to me about whether or not we have new ice cream in the freezer or not. She has so many tells that Greg has been able to help me out with. This Saturday, we have our weekly roundup. As always, that premieres at 6 a.m. Pacific, 9 a.m. Eastern. Again, this Sunday is going to be Sunday Fun Day. Please join us. We have a lot of fun. And then this Monday is another thing I'm very excited about. We've been working on this very hard. We're going to, instead of having another conversation, we are going to premiere for you a very special presentation of our case notes series. And this is on the Brian Kohberger case. We sat down with Kevin Fixler, who is a reporter from the Idaho Statesman, who has been following this case from the very beginning. He got the call when it was first announced that these murders had taken place, and he's been following it on the ground, interviewing people in court for every single hearing. He is the top-notch investigative reporter on this case from day one. And we sat down with him and we did an entire interview on the history of the case, and then we filled that out with other information and other tidbits, and we're very, very proud of this. And so that will premiere this Monday, and we hope that you guys check it out. Monday the 7th. Thank you, Jody. I think you're really going to enjoy it. Monday the 7th at 5 p.m. Pacific, 8 p.m. Eastern. So check it out, guys. That is everything we got going on for this week. We have a lot of new members to thank, so just sit tight and let me get through this. I've already timed it. It's not going to take me more than a minute to do, but these are our brand new members. Esme Grief, Sir Bald and Snarky, Grizzly True Crime, Laura, Doreen Rhymes with Chlorine, Gina Farley, Teresa T, Elizabeth Marie, Hannah UK, Linda G, Songbits Laura, Genzo33, Cherry and Max, Gen X, Gen 8, Jenna Frieslander, Monica B, Peeps, Objection Cake, Pro Hawk Ceviche, which, damn it, that's a good name. Zen Jen, Jenny and GA, Sheena, Beth Moore, Dorothy W17, Karen Collins, Garth Bunt, or maybe I'm saying that wrong, Garth B. Nutt, maybe, Ann Piccolo, Phoenix 808, Alyssa J, Tracy Burns, Linda N, Hidden in the Shadows, Kimberly J, Southern Cali B, Angie, Court Lurker, Arizona Gal 89, Pam R, Iowa Travel Nurse, Georgia Culture, Jackie Arneson, Grassel's Green Enough, Dana Tucker, and Marlena Amarello. You guys are all wonderful, and you're exactly the people that make all of this possible. Perry, thank you so much for the super sticker. Thank you so much, Deanne Mullis Diver, for becoming a new member. Best Nancy for the question and super sticker. Thank you guys all so much. This has been fantastic. Again, a special thank you to Scott and Recovery Addict for joining us. Please check out his channel. If you are not a subscriber of his channel, go subscribe right now. You're not going to regret it. That is all I got for you guys tonight. Thank you again, and we will be talking to you soon. But see us this Sunday and leave us a message. Alicia K says, okay, now say it in reverse. All right, you guys. Take care. Have a wonderful night.